Oyez, oyez, oyez. All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Be seated, please. Case number 22-7067. Aamir Cooper, appellant versus American University. Ms. Park for the appellant, Mr. Remy for the appellate.
Good morning, counsel. Ms. Park, please proceed when you're ready.
Good morning, Your Honors, and may it please the Court. My name is Sumi Park, representing appellant Mr. Aamir Cooper. Summary judgment, I would like to reserve 2 minutes for rebuttal. Summary judgment in this case was not warranted for 2 main reasons. One, because there was a genuine dispute of material fact regarding whether the purported comparators were similarly situated based on comparably serious acts. And second, there was evidence of inconsistent application of the progressive disciplinary policy. And third, the district court made its decision partly based on focusing on the irrelevant similarities, so similarities that were not actually considered, dissimilarities that were actually not considered by the decision makers. We also believe that the university did not show that it held a reasonable and honest belief in the reason for terminating him, which is that Cooper committed sexual harassment. And lastly, if I have time, I would like to just briefly touch upon the suspension issue, but if I do not, I would like to respectfully rest on the brief regarding that matter. First of all, Cooper provided evidence of similarly situated individual, Lieutenant R.S. With the court's permission, I would like to just refer to her as the lieutenant. There is no other lieutenant that is relevant in this case. So Lieutenant R.S. was comparable to Cooper based on Wheeler v. Georgetown University Hospital, a case from this circuit, because it was reasonably inferable and a reasonable jury could find that both the lieutenant and Cooper were accused of committing sexual harassment. And the sexual harassment is a category of misconduct that is stated in the university's sexual harassment and discrimination policy. Like in Wheeler, Nurse Wheeler proposed several proposed comparators, and the record in Wheeler showed that although their actions were sort of labeled slightly differently, Nurse Wheeler was fired for bad performance and failure to follow the the hospital's policies, and the proposed comparators had engaged in actions that involved misadministration of medicine and also
is someone who commits 10 violations of policy comparable to somebody who commits only 1 violation of policy?
Your Honor is asking under Wheeler.
Under Wheeler, under all the case law?
I think based on the case law, the prior bad performance or prior misconduct can be relevant. In Wheeler, I believe Georgetown pointed out that Ms. Wheeler had.
I'm not saying prior. I'm saying that there's an investigation and they conclude that there were 10 violations of policy. And then they have another person who has one violation of policy and they're the same category. Are those, and everything else about them is the same? Are those two people comparable under our case law?
I don't think the number of actions that constitute the violation of the one policy should matter too much, as long as the court and the employer can assess the seriousness of the actions just based on the overall perspective of the misconduct. So one single incident leading to one violation of the university policy may be just as serious as several not so serious violations of the same policy. So
I don't understand how that can be. I mean, if you were given a quiz in school, there's 20 questions. Is a person who misses one question supposed to get the same grade as somebody who misses 10 questions?
So I may be understanding Your Honor's question incorrectly, but as it applies to this case, I know that Cooper has like 4 or 5 complaints that were made against him, and they found him in violation of level 3 of the university policy. And I think the lieutenant has like 2 complaints against her, but underlying the 2 complaints are several different incidents where she engaged in the malicious sexual gossip. So in that sense, we don't think that it should make a difference that there are several incidents that led to the complaint or the number of the complaint.
Maybe one way to ask the same question that Judge Wilkins was getting at is this. Suppose that 2 people are asked the same question. Did you get an A in the class? And one of them got an F and the other one got a B. They both could say no. But doesn't it seem like there's a pretty big difference between the person who got the B and the person who got the F?
So in Your Honor's hypothetical, the person who got the F, is that Cooper?
Well, I'm not even necessarily trying to relate it to Cooper. I'm just saying that just because at some level of generality you could describe 2 people as similarly situated in the abstract, for instance, 2 people who didn't get an A, seems like for a lot of reasons they're not similarly situated because one failed and the other one just barely missed the A. So it doesn't seem like it's enough as a matter of law to say that both the lieutenant and Cooper could at a high level of generality be described as similar in that they engaged in misconduct or that they engaged in misconduct that had some sexual component when the underlying conduct actually is quite distinct.
Yeah, sure, but I actually don't think this wide, well, I don't want to call it wide, but quasi-wide reading of Wheeler is inconsistent with the other precedents from this circuit. For example, I'm not aware of a case where the court just zoned in on the factual differences to consider their actions, to find their actions to be completely dissimilar. For example, in Burley, I do believe the court there said, well, the underlying misconduct is different, but it's because it contributed differently to the train derailment, which was the reason why the plaintiff was fired. And the court found that Amtrak reasonably found that the purported comparator had less of a role, and so his misconduct was less serious than the plaintiff's. And that justified, so that justified viewing them in a dissimilar manner. But to answer Your Honor's question, so we do understand that there are some factual discrepancies between Cooper and the lieutenant's misconduct, but I think it just comes down to how the university characterized it. Like one was characterized as, using a pseudonym and approach the woman in an inappropriate manner. and the other one was accused of gossiping. But at the end of the day, they both engaged in actions that purportedly involved inappropriate sexual conversations. And if you look at the university's sexual harassment policy, there's like 10 different categories of misconduct involving, sex. So sexual harassment is barely one of them. There's sexual assault, rape, more serious categories as well. Arguably, RS's conduct falls into two of them, but one of them is sexual harassment, and that's where her actions and Cooper's overlap, and it should be viewed similarly, we believe. Even if there are factual discrepancies, because they would have to be judged by the same standard if they are reasonably in violation of the same policy, same standard, then it does not make sense to differentiate them on the small differences when the record does not show that it was the small differences that made the discipline distinct and different.
I know you wanted to reserve some time for rebuttal, and
I do.
Make sure my colleagues don't have further questions for you at this time, and we'll give you some time for rebuttal.
Thank you.
Thank you, Ms. Moore. Mr. Remy?
Maybe I will just go to the suspension issue, unless you all think, I'm happy to take any questions on the termination issue, but everything that has come out during argument just now, right, these are different types, that's our position, different, categorically different violations by these two individuals. But the suspension issue, this was the Chambers case, is a relatively new case, so I thought I'd spend a moment on that. So
why isn't your first argument that the district court ruled that there was no clear error, which is required to grant a motion for reconsideration because the suspension wasn't raised in the complaint? Why isn't your argument that ruling should be affirmed?
Your Honor, so the district court agreed to the argument substantively, and our position is that it wasn't, you're exactly that it wasn't raised in the complaint, it was just raised in opposition.
Hey, you say that in your brief, but I mean, I don't understand why you don't say it stronger, because district court's first ruling was under Rule 59E, you don't prevail because there's no clear error, full stop. And then the district court says, nevertheless. So as a good district court judge would do, they have belt and suspenders. Why aren't you relying on the belt? Why are you going to the suspender?
Well, I just thought we'd hit the district court's main opinion, Your Honor, on that, because they just sort of go right past it. The judge goes right past that issue. I do believe that it was that not only was it not raised in the complaint, but we took deposition testimony where Mr. Cooper testified that, yeah, his claim in the case was that he was terminated inappropriately. He actually added a little flavor to that. He said the investigation was conducted unfairly. So it wasn't as if he was just a yes or no answer. He gave his statement. And so maybe we should have emphasized that a little more, Judge. But the district court, I don't really understand how the district court can say there was no clear error and then go on to say, nevertheless, it was raised appropriately. That's probably why I didn't focus on that clear error point, Judge. It doesn't make a lot of, maybe it's just a belt and suspenders argument, but I don't believe it was raised appropriately.
If the termination ultimately should be upheld, then what is the injury from him being put on paid administrative leave? Because if the termination was correct, then he's fired and he gets no salary. So it's almost a benefit for him to be put on paid administrative leave for a while until the termination happens. I'm just not understanding what the injury is here.
Your Honor, we don't believe there's an injury. That's why our argument is there's no adverse action here. The argument has always been that the injury is his lack of access to the pool because he was participating in the Law Fit program and He had an underlying health condition, and so swimming fit very well with his position. This is the argument. Of course, the point is that he was suspended from going to the pool before he was suspended with pay. In other words, after the accusations by these 5 lifeguards, right, that he was sexually harassing them, it's undisputed that he was told not to go back to the pool. Now, there's some dispute about whether that was an instruction versus direct order. There's no doubt there was a conversation with a captain where he was told not to go back to the pool. So there is no...
Yet the district court didn't seem to resolve that. The district court seemed to have acknowledged that there was a dispute about whether it was an order or whether it was just a suggestion.
We agree with the district court in that it doesn't matter. There was some indication that he was not to use the pool, and there's no... And it's undisputed that he was not, whether it's a suggestion, an instruction, or order, all those words have been used. That was directed at him before the paid suspension. So in other words, the plaintiff's hook into a damage from this paid suspension, which is the lack of use of the pool, is not related to suspension.
Isn't it materially different if a supervisor says, maybe you shouldn't do that anymore, shouldn't go there anymore, versus don't go there anymore? I mean, why aren't those two things materially different?
Your Honor, because the reason that distinction doesn't matter here is because, so the alleged damage from the suspension from the university's workforce, the paid suspension, is I wasn't allowed to use the pool. But whether it was just a suggestion or whether it was once he goes, an order, once he goes back to the pool, it's clear he was not going to be able to continue using the pool, whether they put him on paid suspension or not. And we all agree it's reasonable in these factual circumstances. Remember the police department using an alias while talking to students at the pool, that telling him not to use the pool while they investigate this is not an adverse employment action and is perfectly reasonable for him to do. They'd be derelict if they let him go back to the pool in that circumstance. And my only point here is that I agree with Your Honor that there is no adverse employment action because there is no damage from the paid suspension because he was not going back to the pool whether he was put on paid suspension.
But I think there's a difference between saying there's no adverse action and saying that there's no adverse action that's based on an illicit characteristic. It is, isn't it? It is adverse not to be able to go to the pool. It's just everybody can understand why he can't.
Well,
right? I mean,
there's 2 steps there, Your Honor, right? There has to be an adverse employment action, and the next question is it based on an illicit characteristic? The court ruled, right, and the last argument here, and a winning argument, is that whether it's going back to the pool or getting a paid suspension, none of that had anything to do with race or gender.
Right.
That's clear. But even the step before that, should we even get to that point, is being on a paid suspension or being not allowed to use the pool in these circumstances an adverse employment action.
But I don't understand. I mean, on the last point, you might well have a forceful argument, which is the district court did say that the paid administrative leave, was not based on race or any illicit characteristic. But after Chambers, your argument, I guess, is that even if an employer decided to place people on administrative leave, albeit with pay, purely on the basis of their race, that's not actionable under Title VII.
Well, Your Honor, that's kind of looking at it in sort of the last point first, right? I think our point is that to have No,
but I think that has to be it's not looking at the last point first.
No, Your Honor, I don't think so.
Can I finish? It's not looking at the last point first, because if I'm taking the last point out of play, I'm saying, let's assume it is race-based. Your argument, I think, as I understand your brief, is that an employer nonetheless can lawfully decide to place people on administrative leave based on the race, because placing somebody on administrative leave is not an adverse employment action.
That is our argument.
Right.
And the reason for that is because an adverse employment action is the first inquiry in a Title VII case. And so Chambers, right? So there was a Douglas case that said when it's not an obvious adverse impact, you have to have objectively tangible harm. And I guess the question is, does Chambers obliviate that and say that no longer exists, that everything that happens at work is an adverse employment action? Or does Chambers take the position, how I read it, which is that a transfer isn't obvious, does have an obvious harm, because I think one of the lines in that opinion is that the job you hold is essence to the employment relationship. So of course, if you don't get the job you want, whether your pay would have been the same or your hours, doesn't make a difference. That, I don't think that ruling obviates the need for an adverse employment action.
They may well not, but I guess the question is, being placed on administrative leave without pay?
With pay.
With pay, even with pay. Being placed on administrative leave, even with pay, you think is not an adverse employment action?
I think that when there's allegations of sexual harassment and someone is placed on administrative leave with pay during the pendency of investigation, and that leave ends when the investigation ends. Actually, it doesn't start.
What if the investigation takes 5 years?
There could be a limit, Judge. I'm not saying there's never a reasonableness standard. But to be reasonable, what is an employer supposed to do? I mean, what if it's in an office? People are all milling around the same place.
Right, but all of that just goes to whether it's a valid administrative leave, and it may well be a valid administrative leave. It doesn't mean that administrative leave is not an adverse employment action as a matter of law. It just means that an administrative leave very often can be totally justified, and it may be necessary in a lot of situations.
Well,
the question is whether an administrative leave based on race is just, as a matter of law, non-actionable under Title VII, which is your position. I mean, you may well be right that administrative leave in the circumstances of this case and circumstances of many cases is entirely reasonable and necessary to administer a safe and effective workplace. That just seems to me to be quite different from saying administrative leave, even with pay, as a matter of law, is never actionable.
We can take that argument further then, right? We can say, well, the provision of napkins in certain lunchrooms, is that an adverse employment action?
Well, of course. I mean, you can come up. You can say, is a non-adverse employment action an adverse employment action? The answer to that is going to be no. The question is whether an administrative leave is, as a matter of law, not an adverse employment action. And I'm not sure how that could be the case, even if it's with pay, because going on administrative leave, even with pay, can very well be seen as adverse to employees. They'd rather be in the workplace. Not everybody. But certainly some people would rather be in the workplace. There's all kinds of things you're missing out in the workplace. Now, again, it may be justified that you're on administrative leave. But the notion that as a matter of law, administrative leave, even without pay, is non-actionable because it's never an adverse employment action seems to me to be quite a surprising argument.
There are a lot of courts there's a lot of case law behind that. But Your Honor, we're not taking the position that administrative leave with pay, no matter what the circumstances or the length, could never be an adverse employment action. I agree. That would be that would be unreasonable. But looking at it not for the issue of was it based on race or not, without getting to that issue, say in these factual circumstances, is placing someone on administrative leave the length of for 1 month, the length of the investigation.
In the district court, was that your only argument against the motion for reconsideration?
No, Your Honor, there were 3 arguments. There was
What were the other 2?
It wasn't raised below, that's not an adverse employment action, and that there's no evidence that it was based on race, because obviously he wasn't on leave until he went back to school.
It wasn't pretextual.
Right, there's no evidence at all that it's related in any way.
This was a motion for reconsideration on which the judge ruled after granting summary judgment. Our review of the summary judgment is de novo. Is that also true for a motion for reconsideration? It's de novo review?
Your Honor, I understand, maybe I believe that's the case, but given that
I thought it was abuse of discretion.
Abuse of discretion on the granting of the reconsideration, right? But then the judge then grants summary judgment in the motion for reconsideration. So it's sort of right that in the motion for reconsideration, the court grants summary judgment.
Didn't he revise his summary judgment?
Essentially, the court does. Essentially, the district court says,
so why shouldn't that be de novo review? And so if the judge said this is not an adverse employment action, we could affirm on the basis that there's no reasonable juror could find it to be pretextual.
Yes, Your Honor, I believe he could from that basis. So the court does essentially amend the summary judgment motion to address this issue in the reconsideration.
And the court does say that there's no evidence that it's race-based.
It's both. It's both the issues. The court finds that no adverse action and the no evidence.
And isn't it true that plaintiff did not dispute that the university was given these complaints and was investigating these complaints before he was placed on paid administrative?
Oh, yes, there's no dispute of the timeline. There's no dispute as to what the students said during the investigation. There's no dispute as to that's all undisputed. That's all.
So isn't it essentially undisputed that there's no pretext?
I believe so, Your Honor. That's our position.
Okay. Let me make sure my colleagues don't have additional questions for you. Thank you. Ms. Park, we'll give you the 2 minutes you asked for rebuttal.
Thank you. So to answer Judge Wilkins' latest question about the reason for the suspension, we think that is a brand new reason that the appellee provided at this level when it says that, he was basically suspended because he was being investigated. He was never suspended until he purportedly violated an order. And we think that it matters whether or not he received an order because it goes directly to pretext. We think there was enough evidence to show the falsity of the reason that he did not violate an order. He wasn't given an order, but even if he was, he didn't violate it because later Sergeant Salazar gave him permission to go to the pool, which raises an inference that there was never a formal order banning Cooper not to go to the pool. Otherwise, Sergeant Salazar would have been aware and not so easily allow Cooper to go. So drawing all inferences in favor of the plaintiff, Your Honors, we do think that it shows strong evidence of pretext based on the falsity and the comparators, the same two officers that we suggest, the dispatcher BC and Lieutenant RS were not similarly suspended. And there's also evidence of those that were also immediately suspended, which is one of them is an African American female officer and the other is a Hispanic male officer. So we do think that supports Cooper's race and sex claims respectively. And Chief Judge Srinivasan, you brought up a concern about the termination. Like I think you were suggesting, maybe I'm wrong, that was invested and they found him guilty, basically, and maybe you thought that the lieutenant's case was a little different, but the lieutenant was also investigated. She was investigated by the police department, but we think that the investigation itself is faulty and a little biased in her favor. Sergeant Queen had a conversation with Captain Morris in person, expressing his concerns that this investigation was not going to be conducted fairly based on his experience at the police department. Sergeant Queen is an African American male also. And Captain Morse reassured him that no, investigation is going to be, I'll make sure it's fair. But she did not receive any discipline. So we think, we don't think the formal investigation by HR differentiates them because they did commit the same infractions under the same policy. So we believe that Wheeler should have been and should be applied to this case.
Thank you.
Thank you.
Thank you, counsel. Thank you to both counsel. We'll take this case under submission.
Case number 22-7002, Kim Keister, appellant, versus American Association of Retired Persons, Inc. Ms. Clark for the appellant, Ms. Davis for the appellate.
Morning, counsel.
Good morning.
Ms. Clark, please proceed. You ready?
Thank you. After receiving his, filing his complaint against Aetna and AARP Benefit Committee, and understanding it was going to be dismissed, Kim Keister filed a complaint against AARP before a final judgment was entered. This case has been brought because the district court concluded that the claim was barred by both claim and issue preclusion. For the following reasons, the plaintiff says that's incorrect. First of all, with regard to the original case that was brought, it was brought under ERISA Section 502A1B. A1B only allows a participant to enforce the terms of the plan. And in that case, that would have been the contract between AARP and Aetna, so it would have been a claim against Aetna. And AARP's benefit committee was a fiduciary named in that plan who we, at the time we filed the complaint, believed could have been an administrator. So ERISA and the Supreme Court has held that 502A1B claims are limited to enforcing the terms of the plan against the fiduciaries. That's the claim that was dismissed in Keister 1, that's what I'll call it. The claim that's been brought now is about misrepresentation, inducement of Mr. Keister by AARP to sign a contract that waived claims based on misrepresentation of his rights. Now, in Verity versus Howe, the Supreme Court held, and Verity versus Howe is 516 U.S. 489. The Supreme Court recognized that there could be individual recovery under 502A3. A3 could be brought against not just fiduciaries, but non-fiduciaries. This case was brought against the plan sponsor. So it is not a claim against AARP in a fiduciary role, but in a sponsor role.
Let's suppose I agree with everything that you've said. Don't you still have an issue that claim preclusion doctrine is written because they don't want people to split claims? So if you could have brought the claims in the second lawsuit in the first lawsuit, then doesn't claim preclusion still apply?
I answer it two ways. First, I think from a legal standpoint, this court has raised, I think, for plaintiff counsel a real concern about whether or not it's appropriate to do this. And I'll cite the case Clark versus Fader, Simo, and Bard, 527 F sub second, 112, and page 116 of that case. I'm sorry, I think I said it was this court. It was the district court. I apologize. That case was, that complaint had both a 502A1B claim and a 502A3 claim. And the risk that you run with regard to bringing both is that the court might conclude that you're looking for the same remedies, and therefore that you're looking under A3 for the same remedies you could get under A1B. In the case, in Keister 1, there was no ability to conduct discovery. In the case that I've cited, the Clark versus Fader, Simo, and Bard, there was discovery in order for you to reach that issue. Given the fact, I think...
But I don't, I guess I'm trying to understand what you're getting at. I mean, plaintiffs bring alternative theories of liability all the time. A breach of contract claim, a tort claim, a fraudulent inducement claim, and it may be that you can't have double, triple, quadruple recovery because the injuries are going to be, and the remedies, the damages are going to overlap, but that doesn't mean that you get to bring your tort claim and then see how that works out, and then bring your breach of contract claim and see how that works out, and then bring your fraudulent inducement claim, et cetera, et cetera.
Yeah, I disagree to the extent that we're talking about ERISA claims because of the uniqueness of who it is that can provide the benefit. So if this were originally a breach of fiduciary, if Keister 1 was a breach of fiduciary duty claim against Aetna and AARP's benefit committee, and we didn't include AARP as an entity, then I think, yes, we are, I think, claim splitting would be something that's appropriately brought against the plaintiff here. But that's not what happened. Here he was seeking benefits under the terms of the plan, and the only way he could bring those claims was to bring it against the insurance company and the administrator. And AARP is neither in that case. And so I think if he did not have, and which he didn't at the time he filed Keister 1, if he did not have a reasonable basis to understand that there was a breach of fiduciary duty, in this case, a misrepresentation of fact, inducing him into signing his rights away, I think it would have been inappropriate as a plaintiff to bring that claim without any evidence, without a good faith belief that that was a claim that you could bring. It's only after the fact, understanding the position of Aetna and the administrator, that he then understood what the real context of that contract was.
But he could have amended his complaint to add those claims, right?
He made an effort to do that and was basically told that that was something that was not going to be allowed in that case. That was part of the oral argument and summary judgment.
Then your remedy for that is to appeal that denial of the motion to amend.
Which we did, and we were told that the judge was within her discretion to deny that.
So aren't we essentially, in effect, kind of in a position of second guessing that earlier ruling of a prior panel?
I don't think we're second guessing something that wasn't presented to them in total, because what was not presented to that panel were the facts of misrepresentation. What was not presented to that panel were the facts of the omissions. What was before the panel was the contract and whether or not there would be evidence that could be taken with regard to the enforcement of that contract. And I think those are very distinct issues. And if below in Keister 1 or before the panel, there had been issues and facts presented about the misrepresentation that was made to Mr. Keister when he signed his rights away, I think that would be a very different thing. But those facts were not taken into account. They were not allowed to be developed below. They were just considered to be something that would not change the nature of the contract. It wasn't viewed from the standpoint of what induced the person to sign the contract, the omission or the misrepresentation. It was instead looked at from the standpoint of, do we take that into account in order to interpret the contract? And I think that's very different. I did ask to reserve.
We'll give you a rebuttal time. Thank you, Ms. Clark. Ms. Davis, we'll hear from you.
Good morning. May it please the court. I will address Judge Wilkins' question about splitting claims and the ability of Mr. Keister to amend his complaint. As Ms. Clark argued and pointed out, at oral argument, the issue of whether or not there were misrepresentations were raised before the district court. Mr. Keister had the opportunity at that point to raise any facts that would have been a basis to allow discovery on this issue. But even at that stage, we would have objected because it would have been too late and also not in the proper form under the rules for seeking discovery in response to a motion for summary judgment. The proper course, which Ms. Clark should have followed in responding to our argument that the case should be dismissed because of the existence of the severance agreement, would have been to file a Rule 56B declaration and set forth the discovery which she would require. In addition, with respect to amending the complaint could have been amended any time within 21 days after we filed our motion. And she also could have sought leave at that point on the basis that she needed discovery and chose not to.
What was the first response? Did you file an answer, or was your first response motion to dismiss, or was it a motion for summary judgment in the first case?
In the first case, it was a motion for summary judgment.
And so the one free amendment could have been made without any leave of court within 21 days of filing of that motion. Your argument.
I actually misspoke because we did file an answer.
You did file an answer.
But she could have sought leave from the court to amend once she became aware of the existence of this other claim, where she could have brought in AARP. Rather than doing so, Mr. Keister waited to file Keister 2, which is the reason why we're here today, after receiving the order, tentative order from the court on September 30th, and then filed this action on October 1.
I thought there was a motion for leave to amend. No? In the first action, was there not?
There was not a motion for leave to amend. There was an oral request.
Okay, right.
Argument was made, yes.
No, not a formal motion.
Not a formal motion. And the district court did respond by saying that the fact that we're proffered were not sufficient to establish any type of fraud that would have supported a claim for misrepresentation. So Mr. Keister has not been denied the opportunity to raise that legal theory in response to his inability to collect long-term disability benefits. Separate and apart from that, the court also made a ruling that the severance agreement that he signed was enforceable, and therefore he was well aware or should have known about any claim that existed prior to him signing the agreement, and he waived those claims by entering into the severance agreement. So regardless of the fact that Mr. Keister may believe that he could bring a separate action in order to get a second bite at the apple as to his denial of his long-term disability claims, he waived that right by signing the severance agreement. We have the decision in Keister 1, which finds that the severance agreement is enforceable and applying res judicata, therefore he's foreclosed from pursuing Keister 2. And so the district court's decision should be affirmed on that ground.
Can I ask you a question just about claim preclusion doctrine and the way it works? I know it sounds like, and I've looked at the council list, I know you were involved in Keister 1, and so in some ways, it seems like a continuation of that case, even vis-a-vis the parties. But is it the case that anytime there's a judgment involving a subsidiary, that judgment necessarily encompasses the parent also for purposes of claim preclusion, and they're treated as the same party?
Not in every case, but in this situation, we have a common nucleus of facts. This all relates to Mr. Keister's application for long-term disability benefits and his eventual signing away of his rights to bring claims against AARP and any of the other releasees. And so in this case, claim preclusion should apply.
Well, so I take the point that you need common nucleus of operative fact for claim preclusion. I guess I'm just looking at the same parties element of claim preclusion, which is a separate one. It has to be the same party. And I was wondering, is it the case that two parties are necessarily considered the same party for purposes of that part of claim preclusion doctrine whenever one party is the parent or subsidiary of the other one?
If there are facts that establish a connection between the affiliated entities, yes, it would apply. So in this case, we have, in the original Keister 1, there was Aetna, which was the plan administrator, and we had AARP Benefits Committee, which was the plan. And now in this case, we have AARP, which is the plan sponsor. And so there is a relationship between all three parties.
And you mean a relationship between, there's always a relationship between a parent and subsidiary, at least in a formal legal sense, because one's the parent of the other. You're not saying that in and of itself is enough to render them the same parties. There has to be more of a relationship than that?
Yes, that's my position.
And the more of the relationship that's present here and this suffices, is that the parent and the subsidiary are both involved in the administration of plan benefits? Is that?
That's correct.
That's the way you're looking
Is
at it?
that disputed in the district court?
I don't believe it was disputed.
Yeah, I thought that was a given, that the subsidiary and the parent were in privity with one another. It was not litigated.
Right, in Keister 1, there was...
Let me ask you another question. I've just looked at, I was not aware that you filed an answer, and I looked at the docket sheet.
I may be mistaken. I thought we had...
There's no answer in the docket sheet.
I may be mistaken then with my recollection.
Yeah, okay.
Thank you, counsel. Unless you have anything further, I think we have no further questions.
Nothing further, just request that you affirm the decision. Thank you.
Thank you. Thank you. Ms. Clark, we'll give you the 2 minutes you asked for rebuttal.
I'd like to address the issue that was just raised about the parent and the subsidiary. I think in the ERISA context, you cannot look at it the same way. The fiduciary is completely independent of the plan sponsor, and their functions are completely different. Acts to amend the plan, for example, cannot be considered fiduciary acts, and those are typically the acts by a plan sponsor. In this case, we're talking about a misrepresentation that's being made by a plan sponsor. That is action. And so I think that they are, because there are distinct acts between the administrator and the distinct act by AARP, in this case, their HR department, that the Keister 1 could have never addressed the HR department because their acts were not part of that original case. And they couldn't have been under a 502A1B claim because, again, a 502A1B claim is limited to enforcing the terms of the plan. And the plan would have been the insurance contract between AARP and Aetna.
Just so that I make sure I understand your argument, you aren't contending that because of some sort of joinder or any other kind of rules, you couldn't have brought the claims in Keister 2 in Keister 1, right? There's nothing, no law or rule or procedure that would preclude you from bringing those claims together against all of the relevant parties, right?
If I had amended the plan to add AARP as a defendant, I could have brought the claim. Okay. With the existing defendants, I could not have brought them.
So the issue was not that you were prevented from doing so by any sort of a rule or principle or doctrine or law. It was that you weren't aware of the basis for Keister 2 when you brought Keister 1, the factual basis.
Factual basis. That is correct.
I think Judge Randolph asked a question of your friend on the other side this. Did you challenge whether there was privity between AARP and the fiduciary, as you put it? Did you challenge the privity argument below when that was raised as a basis for a claim or issue conclusion?
I challenged the privity issue.
That they weren't the same party. Did you argue that they weren't the same party below?
I believe that we did. I mean, because they are not the same party. I mean, I believe that our arguments have been very consistent that because the claim is being brought against the plan sponsor, that's a completely different entity than the fiduciary or administrator.
Thank you.
Thank you.
Thank you, counsel. Thank you to both counsel. We'll take this case under submission.
Case number 22-1028, National Association of Immigration Judges, International Federation of Professional and Technical Engineers, Judicial Council 2, Petitioner versus Federal Labor Relations Authority. Mr. Garcia for the petitioner, Ms. Osborne for the respondent.
Good morning, counsel. Mr. Garcia, please proceed when you're ready.
Good morning, Your Honors. May it please the court and counsel. My name is Abiel Garcia, and I represent the National Association of Immigration Judges. Acting in haste to deprive immigration judges of their right to belong to a union, the majority has cobbled together a decision that ignores authority precedent covering both the review of unit certifications and the scope of the management official exclusion. This is a direct quote from now Chairman DeBester regarding the authority's 2020 decision. This statement underpins the repeated due process violations committed by the authority. The union is before this court today to ask that the court vacate the authority's 2020 decision decertifying the union and a subsequent 2022 decision denying a motion to reconsider, and then remand this case back to the authority so it can issue an opinion consistent with due process. In overruling the regional director's detailed and methodical 25-page analysis, the authority's 2020 and 2022 decisions are, as now Chairman DeBester summarily stated, quote, the antithesis of reasoned decision-making, unquote. Both opinions fail to grapple with any of the regional director's factual or legal findings, and at no point does the authority hold that the regional director erred in any way.
So there's some threshold questions about whether this case is properly before us based on the way it came up. And,
yes, Your Honor.
And it's undisputed, I think, that at the time that you brought your petition for review, there was a motion for reconsideration pending before the agency.
Yes, Your Honor.
And why doesn't that just run squarely into the general doctrine that when there's a motion for reconsideration pending, the bringing of a petition for review is incurably premature?
So that motion to reconsider specifically asks for a motion to reconsider EOIR or EOR 2022, the authority's 2022 decision.
Would you mind just raising the mics just a little bit?
Yes,
to make sure
apologize.
Yeah, that's right.
There you go.
Speak a little louder, please.
That motion to reconsider, which was filed after the authority's 2022 decision, was asking for a reconsideration of 2022 decision, right? And so at that point, we hold that EOIR 20 or EOR 2020 was final because we were not asking for reconsideration at that point in 2020. And it actually, in the authority's 2022 decision, it even dismissed the union's motion for reconsideration. And so at that point, what we said in our briefing as well was, if it was incurably premature, it would only be with respect to the authority's 2022 decision.
But what would be the sense of splicing it that way? Because the reason we have the incurable prematurity doctrine is that something might happen in the still ongoing proceedings before the agency that would affect our review, including in rendering it entirely unnecessary. And that's going to be the case, even if, I'm not sure it makes sense to splice it in the way that you are, but even if you thought that it could, still have the same problem, because whatever was pending before the agency could still have the effect of rendering our review unnecessary.
Our understanding is that they wouldn't, because we were asking for reconsideration of 2022 decision, which was, again, just analyzing a reconsideration already, that whatever effect or decision taken by the authority would not have affected the 2020 decision, which is the primary decision we're driving.
How could that be? Because the 2020 decision, then we would just be addressing a decision that would have been superseded in the agency itself by whatever it did with the 2022 decision.
Because the 2020 decision, in our view, is an actual appropriate unit determination, and then the 2022 decision is whether or not they should reconsider that. Our further reconsideration after that would then be whether or not they would properly looked at to reconsider the original opinion. But that had no effect on whether or not they were going to.
Well, suppose they granted reconsideration and they actually gave you everything you asked for. Then we would still be looking at a decision that had already been reconsidered and as to which you'd already gotten the granted relief?
Well, we'd ask for a further briefing in terms of we had a pending motion to stay and remand for further fact finding that never got ruled on, and so I don't know if the court would have given us everything exactly would have helped effectuate or helped provide the relief we were looking for.
This problem arose in the federal courts, not in the context of administrative law, but in the context of federal civil procedure and federal rules of appellate procedure. And it created what the advisory committee called a dire trap for the unwary. And so the federal rules of civil procedure, of appellate procedure, now provide to solve the problem that Judge Srinivasan has mentioned, now provide that if the motion for reconsideration is denied, that is the point in which the premature notice of appeal ripens. And so nothing goes forward until the motion for reconsideration is heard. Now, I don't know where this doctrine came from for sure in our court, this incurably premature, but it looks like it came from a per curiam opinion in about 1985 before any of the federal rules abolished that. And the other thing I don't know is whether it's ever been applied in the FLRA context. Are you aware of it? Ever be that incurably premature?
I am not aware of any.
Because you can't find that in the judicial review provision. You can't find anything of that sort in the judicial review provision for FLRA decisions. So if you're a counsel and you're looking at it and you pull out whatever it is, 703, is it?
That's 703, please.
Yeah. You pull that out and you read it, and you wouldn't have a clue that if you file a motion for reconsideration, you can't file a petition for rehearing or for judicial review.
Correct, Your Honor.
Yeah.
But aren't there timelines, time limit to file your petition for review?
Yes, there is a 60-day after.
So how is a petition for review filed in 2022 timely as to the order in 2020 that you say you're really seeking review of?
So the petition for the reconsideration motion on the authority's actions in 2022 are a further extension of just the repeated due process violations that happened over the course of the 3 years of the underlying litigation. So that's why the motion to reconsider in 2022 is specifically asking to reconsider the authority's 2022 opinion. Because if we had tried to link it back to 2020, it would be improper or untimely.
But then that just proves that it's incurably premature under our precedent, because now you're saying that the argument that you're making for us today, which is that there are due process violations, are the arguments that you were making in your motion for reconsideration.
Well, we were raising further due process violations to the court in our 2022 reconsideration, but those there are underlying issues in due process violations that happened in 2020 that we think are properly before this court and are not subject to the incurable premature argument.
But you didn't flag those. I mean, there's another issue here, which is whether you raised the arguments before the agency. And I don't know how you could have raised arguments about due process vis-a-vis the initial decision, because I think the due process claims primarily relate to things that happened after the initial decision or in the consideration of the initial decision.
So our November 17, 2020 motion to reconsider after the authority's 2020 decision flags the specific arguments about the lack of a reasoned opinion, discusses the issue with the announcement of this new rule that winning parties have to file a cross appeal on a winning decision. Those arguments are flagged in our November 17, 2020 briefing to the authority.
Right, but even if we thought that those were due process arguments, and I think there's a question about that, but even if we thought that, that would be after the decision that you're saying that it's before us.
That is after the first decision that is before you, after the authority's 2020 decision, because up until that point, the authority had not announced this new prophylactic rule, and up until that point when the authority issued 2020, the regional director's decision was the controlling decision, which is the well thought out methodical 25-page analysis.
So that's your extraordinary circumstance?
Well, the extraordinary circumstance, Your Honor, would be the fact that the regional director took the time to analyze the actual day-to-day duties of an immigration judge, went through the criterion as to what a management official is, how it interplays with the immigration judge's duties, and at the end of the day, it made the analysis that immigration judges at this day and time, in 2020, are not management officials. The extraordinary
That's not what I was referring to. I was referring to the jurisdictional statute that prohibits a court from reviewing an objection that was not made before the agency, except when there's extraordinary circumstances.
I understand, Your So our argument is that we have made the same arguments to the authority multiple times since the November 17, 2020 motion, and have repeatedly been raising this argument over the past 2 years. So to be clear, right, the regional director's decision really analyzes a lot of different issues and findings. For instance, whether the Board of Immigration Appeals continues to review and remand cases, how immigration judges implement immigration policy, and there's scores of others, right? But none of these are discussed in the authority's 2020 or 2022 decisions, right? The linchpin of the authority's 2020 decision comes down to one issue, and the authority explains, quote, arguing immigration judges' decisions do not influence agency policy while board member decisions do is akin to arguing that district court decisions do not shape the law while appellate court decisions do. Such a distinction, based on what appears to be solely reviewability of decisions, is nonsensical, end quote. This is the sole explanation.
I think we have the merits of your due process argument from your briefing, and I just want to make sure you reserve some time for rebuttal.
Some time for rebuttal, yes.
And we will give you that time if our colleagues don't have any additional questions for you this time.
Thank you, Your Honors.
Thank you, Mr. Garcia. Ms. Osborne, we'll hear from you now.
Your Honors, may it please the court. The immigration judge's petition for review should be denied in its entirety. With respect to the constitutional claims, the FLRA's assessment of the unit certification petition satisfied any due process rights that the union had with respect to the claims.
What exactly is your understanding of the due process claim that's been raised?
There are two due process claims, and they were not raised by the union until the second motion for reconsideration, which was still pending when the petition for review was filed. And just to clarify, we had also raised the premature, incurably premature argument when the union filed its emergency motion for stay.
What are the two due process claims?
Substantive due process and procedural. And we argue.
But that doesn't. What is the procedural due process?
The procedural due process claim, they have argued that they have a liberty interest that was violated by the authority. First, because they had not had the opportunity to assert that there had not been a substantial change to the unit. And that's simply not true. They could have raised that issue. They lost the issue of substantial change before the regional director. The regional director found that there had been a substantial change in the unit, but the regional director found it didn't alter the character of the unit. The authority, when applications for review were made to the regional director's decision, the agency filed an application for review, but the union did not. And so the authority properly held under the regulations that the issue of substantial change had been. And that's because it was waived, and the union should have brought that claim under section 2422.31. They also claimed that the authority violated due process rights because there had been a rush to have a dissenting member finalize a draft dissent decision. And that's actually not accurate because the decision had actually been in the process of being drafted. And the majority had simply stated that they were intending to issue the decision within 21 days and ask the dissenting member to finalize his decision within 21 days. They've also said that the case was not moot at the time that the authority rendered the second decision denying the motion for reconsideration, and they say that's because the parties had entered into a settlement agreement. But the problem is that the statute gives to the authority alone the ability to determine an appropriate unit, and it's not something that parties can settle. And there is authority case law going back to 1990 that says the fundamental principle of the statute that parties cannot negotiate over the unit status of employees.
Yeah, the idea is that the employer then provokes an unfair labor practice charge and refuses to bargain, and then you determine, and one of the defenses is an inappropriate unit, right? how can this union ever provoke an unfair labor practice charge?
Well, it could have actually provoked an unfair labor practice charge because it had a valid, live, unfair labor practice complaint that was being prosecuted through the Office of General Counsel as of December.
There can't be a refusal to bargain if the union is not recognized.
Well, but there is an individual could have.
Well, an individual, yes, an individual. I saw that in your brief, but that's not the union.
But the union itself had live complaints as of December of last year, and those complaints could have moved forward. But the union chose.
I don't see how. I frankly don't see how.
Well, Your Honor, those complaints were live, and if you look at the settlement agreement, the Office of General Counsel at that point, because the union had not yet been decertified, had said.
Well, that's another question I had. I just want to make sure in the National Labor Relations Board context, which you use rightly as an analogy, an individual or a union can't, or even an employer, cannot bring an unfair labor practice charge. That's up to the General Counsel. And they can go to the General Counsel and request them to do that. Is that the same situation in the FLRA?
And in this case, the union had filed 5 separate charges. The Office of General Counsel consolidated those charges and issued a complaint.
Okay.
So that's when I say that there was a live complaint as of December of last year. There was, and the Office of General Counsel was prepared to prosecute. Also in this case, the union has already filed for recertification of the union, and there's going to be a hearing on that for the regional director.
That has not been decided.
It has not been decided. The hearing is going to be held in January. The parties had asked that proceedings.
Has the composition of the FLRA changed since 2020?
Yes, it has. In any event, one of the issues that I did want to raise about the need to exhaust is Congress clearly did not intend for appropriate unit determinations to be directly reviewed in courts. We are concerned that a direct review of a constitutional claim will provide an incentive to parties to bring challenges to appropriate unit determinations as constitutional claims. And this is important institutionally because there are at least 4 different decisions among different FLRA components. And those components have non-reviewable decisions, and you can only get reviewed indirectly. So, for example, there were 5 challenges to FISIP decisions in district courts over the past 5 years. Those courts held parties in the cases had to administratively exhaust through the ULT process, which is reviewable by the court. If that was not the case, then parties could simply challenge the FISIP decisions, authority decisions, and other non-reviewable decisions directly in the court by raising concerns.
Yes, you sort of mentioned in passing in your briefing, I think it was in your reply brief, the principle that if the party didn't raise the argument before the agency and give the agency to address it, then we lack jurisdiction over it.
That is also true.
But are you relying on that argument? Because I think there may be if it's jurisdictional, it doesn't matter whether you specifically invoke it, but your briefs didn't make much of an argument to that effect.
In my brief or before you today, I can make the argument before you today. I think that. I
guess I'm wondering, did you not emphasize it in your briefing because you have a concern about its applicability here? Or
no, I don't, Your Honor. I think claims need to be administratively exhausted, and in this case, it goes also to the issue of prematurity, because the constitutional claims were not raised before the authority in the first motion for reconsideration. It's only in the second motion for reconsideration, and the union filed the petition before this court before the authority could address it.
I think it's an odd formulation. The way I understand it, and I'll ask counsel for the union, is the claim is that the decision of the board or the authority was arbitrary and capricious, and therefore it denied us due process, which is just a kind of fancy way of saying it violated the APA.
That is a concern that and I think the Supreme Court said in FCC v. Fox that there is arbitrary and capricious under constitutional standards are different from arbitrary.
See, that's an objection that it's never made before the agency, no matter which agency it is, whether it's the board or any other FCC or whatever. It's an objection that's always made for the first time in our court, obviously, because you can't make it without having the decision already come down. It's arbitrary and capricious. So that doesn't fall within the prohibition of whatever 7123 or C or something like that.
Well, the problem with that is, Your Honor, that because there is no direct judicial review of unit determinations, Congress didn't intend that exhaustion of constitutional claims should be exhaustion in indirect review, the same way that it would be under a simple, challenge statute. That's.
Okay.
Thank you very much, Your Honor.
Thank you, counsel. Mr. Garcia, we'll give the 2 minutes for rebuttal.
Thank you, Your Honors. The first one I want to talk about is the due process issue and when it was raised, right? So this is a quote from our motion to reconsider on November 17, 2020. Quote, the authority erred in at least two ways. One, it incorrectly concluded that this renewed attempt by the agency to rid itself of the union was not an unlawful collateral attack on a previous unit certification. And two, ignored its own precedent and agency regulations. It's the fundamental things we've been raising for 20 years or for the past 2 years, and it's in our briefing. It's been before the agency or the authority for at least 2 years.
But it seems to me quite different to say that it's wrong and to say that it's a violation of due process. Assuming that assuming that this is the type of thing that you could have raised and that doctrine applies here, those aren't the same thing.
We believe that it raises to the level of a constitutional violation because we pointed out the same issues about the flippant nature of the decision, the lack of analysis of the regional director's decision. That's why we think these arguments.
That's just an arbitrary and capricious argument.
So to the statement about arbitrary and capricious, right? The County of Sacramento case has held that, quote, we have emphasized time and again the touchstone of due process is protection of the individual against arbitrary action of government, whether the fault lies in the denial of fundamental procedural fairness or in the exercise of power without any reasonable justification in the service of a legitimate government.
Yeah, so you read that, and it means every case that we've decided that an agency has acted arbitrarily and capriciously, we've also decided that it's a violation of the Constitution. I don't think that's correct.
I agree with you on that not every single time that someone acts arbitrary and capricious is a constitutional violation, but in this context, right, having one sentence that essentially tries to justify overturning the 20-year-old union does shock the conscience, coupled with the fact of now Chairman Dubester's, two dissents talking about how he believes this was results-driven decision-making. And to the final argument on jurisdiction, we believe that Griffith is controlling in this case, which did allow constitutional claims to be appealed under 7123A1, which shares the same legislative history as 7123A2. And because of that allowance, we have seen no cases that have flooded this court with constitutional claims on appeals for 7123A1. Thank you, Your Honors.
Thank you, counsel. Thank you to both counsel. We'll take this case under submission.